Welcome dear friends. Today our topic is Privity of Consideration and Privity of Contract. In this lesson, you will be able to understand the concept of privity to consideration, privity to contract and its exceptions. It is well settled rule of English law that consideration must move from the promisee alone. If it is furnished by any other person and not by the promisee himself, the promisee becomes stranger to consideration, therefore cannot enforce the promise. This is known as the doctrine of privity of consideration. The doctrine of privity of contract means only those persons who are party to contract can enforce the same. A stranger to contract cannot enforce. In England, both the propositions, that is, privity of consideration and privity of contract, are applicable. And in India, only one is applicable, that is privity of contract. Now let us discuss these two propositions in detail. Privity of consideration. Privity of consideration means that the act or an abstinence or a promise constituting the consideration must be done or made by the promisee himself at the request of the promiser. But the words promisee or any other person given in the definition of consideration under section 2D of the Indian Contract Act indicates that consideration need not move from the promisee alone but may proceed from a third person on behalf of the promisee. To that extent, Indian Contract Act has departed from the rule of English law. The definition of consideration under the Indian law is therefore wider than in English law. Under the English law, a stranger to consideration cannot sue the promiser. But in India, the law is otherwise, and here even a stranger to the consideration can sue on contract, provided of course that he was a party to the contract. Privity of consideration not applicable in India. The rule of privity of consideration is not at all applicable in India in view of the clear language used in section 2D of Indian Contract Act. It is not necessary that a consideration should be furnished by the promisee only. Here in India, a promise is enforceable if there is some consideration for it and it is quite immaterial whether it moves from promisee or any other person. The leading authority is the decision of Madras High Court in Chennaiya vs. Ramaiah. The facts of this case are: A, an lady gifted away her property to her daughter B and directed B to give an annuity of Rs 650 every year to P. On the same day, B executed an agreement in favor of P, promising to carry out A's directions. B stopped paying annuity of Rs 650 to P after some time and thereupon P sued B. P's claim was decreed. In this case, it should be noted that although P was a stranger to consideration because consideration for B's promise to pay Rs 650 annuity to P was given by A, who gifted of her property. But P was not a stranger to contract and the case was governed by the provisions of Indian Contract Act. Thus, P's claim was decreed. Firstly, the rule in India is that consideration shall move from the promisee or any other person. Secondly, failure to keep promise would have deprived the plaintiff P of an amount which he was already received from the old lady. And if a promise causes some loss to the promisee, that is sufficient consideration by the promisee. Thirdly, the deed of a gift and the defendant's promise to pay the annuity was executed simultaneously on the same day and therefore they should be regarded as one transaction. And there was sufficient consideration for the transaction. Therefore, defendant B was bound to pay. Although the defendant contended that since the plaintiff P himself had furnished no consideration, he had no right of action against her to claim annuity. That is, the defendant pleaded privity of consideration of English law. But her action was not accepted by the court and it was held that English doctrine of privity of consideration is not applicable in India. It means that under Indian law, a person may not himself give any consideration, but he can enforce the contract if he is party to a contract. In India, the rule stranger to contract cannot sue has to be distinguished from the rule stranger to consideration can sue. Because in India, stranger to consideration can sue but stranger to contract cannot. That is, doctrine of privity of consideration is not applicable in India, but privity of contract is applicable both in India and England. Privity of contract. A contract cannot be enforced by a person who is not a party to it, even though it is made for his benefit. He is stranger to contract and he can claim no right under it. This is known as privity of contract. In 1861, the general rule of privity of contract was laid down in case of Tweedle versus Atkinson and was adopted by the House of Lords in various cases, and which subsequently came to be known as the Doctrine of Privity of Contract, which means a contract is a contract between the parties only and no third person, that is stranger, can sue upon it even if it is avowedly made for his benefit. In this case, the plaintiff A married a girl B. After this marriage, there was a contract in writing between A's father and B's father that each would pay a certain sum of money to A. After the death of the contracting parties, A brought an action against the executors of B's father to recover the promised amount. It was held that A cannot sue for the same on the ground that he was a stranger to contract as well as stranger to consideration. Thus, although the sole object of the contract was to secure benefit to the plaintiff, he was not allowed to sue as the contract was made with his father and not with him. The case laid down the foundation of the rule privity of contract, that is, stranger to contract cannot enforce the contract. The rule was affirmed by the House of Lords in Dunlop Pneumatic Tyre versus Selfridge and Company. Dunlop and Company sold certain goods to one Due and Company and secured an agreement from them not to sell the goods below the listed price, and if they sold the goods to the another trader, they would obtain from him a similar undertaking to maintain the price list. Due and Company sold the goods to the defendant, that is Selfridge and Company, who agreed not to sell the goods to any private customer below the list price. But the list price was not maintained by S and Company. The plaintiff sued the defendant for the breach of contract. The House of Lords held that the contract was unenforceable as the plaintiff company was not a party to contract between Due and Company and S and Company. It was also held that even if it is taken that Due and Company were acting as an agents for the Dunlop and Company, the latter still cannot maintain an action as there was no consideration between Due and Company and S and Company, because the whole of the purchase price was paid by S and Company to Due and Company. Now let us discuss the critical analysis of the privity rule. The rule of privity of contract has taken on firm roots in English common law and was adopted by a House of Lords, but has been generally criticized. In 1937, the Law Revision Committee, under the chairmanship of the Lord Wright, criticized the doctrine and recommended its abolition. Lord Denning has also criticized the rule in number of cases. In Biswick versus Biswick, he observed, I quote, "Where a contract is made for the benefit of a third person who has a legitimate interest to enforce it, can be enforced by a third person in the name of contracting party or jointly with him, or if he refuses to join, by adding him as a defendant because a third person has an interest which the law should protect. It is different when the third person has no legitimate interest, as when he is seeking to enforce and maintain the list price to the public disadvantage, as in Dunlop Pneumatic case, or when he is seeking to rely not on any right conferred upon him under the contract, but on an exemption clause seeking to exempt himself from his just liability, unquote. In the instant case, B was a coal merchant. The defendant was assisting him in his business. B entered into an agreement with the defendant by which the business was transferred to the defendant. B was employed as a consultant, and after B's death, the defendant has to pay to B's widow a sum of £5 per week out of a business assets. After B's death, the defendant paid B's widow only one sum of £5. The widow brought an action to recover arrears of an annuity and the specific performance of the agreement. In appeal, the House of Lords did not approve the approach adopted by Lord Denning and observed, I quote, "The plaintiff lady in her personal capacity has no right to sue, but she has a right as an administrator of her husband's estate to require the defendant to perform his obligation under the agreement." The case shows that a reform, as was recommended by the Law Revision Committee in 1937, is long overdue, and if the Parliament takes any step in this respect, that would hardly be revolutionary. Stein Lord Justice also criticizes the doctrine in Darlington BC versus W.S. Northern Limited in the following words, I quote, "There is no doctrinal, logical or a policy reason why the law should deny effectiveness to the contract made for the benefit of the third party, where that is the expressed intention of the parties. It is therefore unjust to deny effectiveness of such a contract. I will not struggle further with the point since nobody seriously asserted the contrary." Unquote. In some earlier cases, the House of Lords showed no preferences for Lord Denning's approach. Lord Simmons said that if the principle just coestem tertiure is to be introduced in our law, it must be done by the Parliament after a due consideration of its merits and demerits. Unquote. Now the position in India. In India, there is no provision in Contract Act either for or against the rule. There has been a great divergence of opinion in Indian courts as to how far a stranger to contract can enforce it. There are many decided cases which declares that contract cannot be enforced by a person who is not a party to it, and that the rule laid down in Tweedle versus Atkinson is as much applicable in India as it is in England. However, with the passage of the time, the courts in India have created certain exceptions to the rule, and there are various cases in which it was held that a beneficiary, third person under the trust, family arrangements and the various laws can sue or enforce his rights. Decision in favor of rule of privity of contract. The rule was first applied by the Privy Council in 1911 in Jamna Das versus Ram Avatar, where A borrowed Rs 40,000 by executing a mortgage of her zamindari in favor B. Subsequently, A sold the property to C for Rs 44,000 of the price in order to redeem the mortgage if he thought fit. B sued C for the recovery of the mortgage money, but he could not succeed because he was not a party to an agreement between A and B. The Privy Council held that the undertaking to pay back the mortgagee was given by the defendant to his vendor. The mortgagee has no right to avail himself of that which he was not a party. The purchaser entered into no contract with him, and the purchaser is not personally bound to pay B his mortgage debt. In the opinion of Banking Chief Justice, this seems to be the effect of the Contract Act itself. In Krishnan versus Pamela Bala, his lordship observed, I quote, "Not only, however, is there nothing in section 2D to encourage the idea that contracts can be enforced by a person who is not a party to contract, but this notion is rigidly excluded by the definition of the promiser and the promisee. In my opinion, it is erroneous to suppose that in India, persons who are not the parties to a contract can be permitted to sue thereupon." Unquote. The Supreme Court of India has expressed itself in favor of the privity rule laid down in Atkinson's case in MC Chakku versus State Bank of Travancore In the present case, the Highland Bank was indebted to the State Bank of Travancore under an overdraft. One M, who was a manager of the Highland Bank, and his father K has guaranteed the repayment of an overdraft. K gifted his properties to the members of his family. The gift deed provided that the liability, if any, should be met by M either from the bank or from the share of the property gifted to him. The State Bank attempted to hold M liable under this provision of the deed, but M was not liable. The Supreme Court held State Bank of Travancore, not being a party to the deed, cannot enforce the covenant and was bound by them. It is a settled law that a person who is not a party to the contract cannot enforce its terms. Decision against the rule. There is, however, another line of thinking which is mainly based upon the observation of the Privy Council in Khwaja Muhammad Khan versus Hussaini Begum. In India and among the communities circumstanced as Mohammedans, among whom the marriages are contracted for minors by parents and or the guardians, it might occasion serious injustice if the common law doctrine was applied to agreements or arrangements entered into in connection with such contracts. This statement has been also taken by some high courts as laying down the rule that Indian courts are not bound by the rule enunciated in Tweedale versus Atkinson. For example, the Madras High Court in M. Naikar versus M. Naikar observed, I quote, in this country and indeed in a certain class of cases in England where a contract is entered into between A and B for the benefit of C, C is entitled to sue the defaulting party, unquote. The Calcutta High Court in Kishordi Bihari versus Mangudu Binda observed, I quote, there is no provision in the Indian Contract Act either for or against the rule, nor is there anything which prevents the recognition of a right in a third party to enforce a contract made by others which contain a provisions for his benefit, unquote. The Supreme Court in M.C. Chakku versus State Bank of Travancore, Shah Chief Justice observed, I quote, it must therefore be taken as well settled that except in certain cases of beneficiary under a trust or under a family arrangements, no right may be enforced by a person who is not a party to contract, unquote. Thus, courts have also introduced a number of exceptions in which a rule of privity of contract does not prevent a third person from enforcing a contract made for his benefit. The Calcutta High Court in the Raymond Woolen Mills versus Coal India Limited observed, I quote, the doctrine of privity of contract has undergone a change in the recent years and therefore the principal as a beneficiary under a contract can initiate a legal action against a third party without being a party to the contract, unquote. The above rule that stranger to contract cannot sue is subject to certain exceptions introduced by the courts in India from time to time, in which the privity rule does not prevent a person from enforcing a contract which has been made for his benefit without being a party to contract. Some of the exceptions are connected with a special branch of law, that is law of contract, such as Transfer of Property Act, Negotiable Instrument Act, Consumer Protection Act, etc. Some of the commonly known exceptions are, first, beneficiary under a trust or other arrangements, where a contract by its express terms purports to confer a benefit directly on the third party shall be entitled to enforce the provision in his own name, provided that the promisor shall be entitled to raise against the third party any defense that would have been valid against the promisor. In case of Rani Baksh Singh versus Jang Bahadur, decided by the Privy Council, where R was appointed by his father as his successor and was put in possession of his entire estate. In consideration thereof, R agreed with his father to pay a sum of money and to give a village to J, the illegitimate son of his father, on his attaining majority. It was held by the Privy Council that in the circumstances mentioned above, a trust was created in favour of J for the specified amount and the village hence entitled to file the suit. Keeping in view the importance of a social-oriented legislation enacted for the benefit and the welfare of the people, for example, the Consumer Protection Act 1986 and the other related laws in which the rule of privity of contracts finds no place. Second, marriage settlement, partition or other family settlements. Where a provision is made in a partition or in family arrangements for maintenance or marriage expenses of a female members, such members, though not party to agreements, can sue on the footing of the arrangements. Acknowledgement or estoppel. Where by the terms of a contract, a party is required to make a payment to a third person and he acknowledges it to that third person, a binding obligation is thereby incurred towards him. Acknowledgement may be express or implied. This exception covers the cases where the promiser by his conduct acknowledges or otherwise constituted himself an agent of the third party. Covenant running through lands. The rule of privity may also be modified by the principles relating to transfer of immovable property. The principle of famous case Tulloch versus Moxie is that a person who purchases a land with notice that owner of the land is bound by certain duties created by an agreement or a covenant affected the land shall be bound by them, although he was not a party to an agreement. With this, I conclude today's topic. Thank you for watching.